Hey, good morning. My name is David McCaleb, and on behalf of Bankers Insurance and SESCO Management Consultants, I'd like to welcome you to today's webinar on the new Virginia Overtime Wage Act and some permanent COVID safety standards. The webinar is being recorded, and I'm going to share the recording with everyone registered at the conclusion of the webinar. Basically in the same way you guys probably just a few minutes ago, maybe 20 minutes ago, received an email from me kind of reminding you about the webinar. It's going to come out the same way. I'll share the link to the recording in the same manner. There's going to be some Q&A at the end of the webinar, but everybody should have a Q&A or chat feature, a Q&A feature on the webinar. And so as we go through, don't necessarily feel like you have to wait till the end. Go ahead and place your questions in the chat feature, and we'll either hit on them as time allows during the webinar or at the end. And now I'd like to introduce Jamie Hastie, Vice President of SESCO Management Consultants. We've partnered with Cesco for many, many years, and they do a wonderful job providing human resource and employee relations consulting to our business clients. And so with that, I'm going to turn it over to Jamie. Thank you so much and welcome.
Thanks, David. Good morning, and good morning to everybody. It's a pleasure to be back with you. We try to do these team meetings or Zooms every quarter, so it's always good to be with my bankers family. And Cesco has had the pleasure of partnering with bankers since 2012. Shortly thereafter, the Affordable Care Act came into play, and so we have the privilege of offering some basic telephone and email consulting services to bankers' clients, with the ability for higher level services based on client needs and other things going on. So if you've had the opportunity to take advantage of that program, that is extraordinary. If you are thinking, Jamie, what is that program? What do I need to do to access or have the ability to access Cesco and our attorneys and consultants? Reach out to your broker or your account manager rather, and we can explore how to get you enrolled in the telephone and email access. So today we are going to talk about what's going on here in Virginia. July 1, there were a few changes both to the Overtime Act, and that can get a little nitty gritty. So bear with me. I may talk a little bit about the federal side of things and how that differs a little bit from what Virginia did. It's, in the grand scheme of things, it's not overly huge. In my world, it's not. But for other people, it's quite disruptive when you're like, wait, what? How do I calculate it now? So there are some changes there. There are some other things that we're going to hit on, like legalization of marijuana, the Virginia Change in Pregnancy Act, those sorts of things. We're also going to dig a little bit into the vaccine mandate. David and I were talking this morning, and we are getting a ton of questions on, do we mandate the vaccine, do we not? And that's not anything new. We've been getting a ton of questions on that to begin with, but as numbers are increasing, as things are rapidly changing within the state, within your local area, we're seeing a lot of push of, what do I do? And there's a lot of pressure on employers as to what they do. So we'll dig into, can you mandate it? What does that look like? Should you leave it voluntary? Again, it's a business choice based on your industry, your workforce, but there are some legal items surrounding it that you need to be aware of. We will talk more fluidly about the Virginia permanent standards as well as the OSHA ETS, because there seems to be a lot of confusion out there about the OSHA safety standards. Keep in mind that literally recommendations from both CDC and OSHA change almost daily. So what information may be presented today may be, quite frankly, out of date by this afternoon, depending on if OSHA and CDC come out and provide additional guidance. That's why it's really, really important to stay in the know with your consulting team, your employment attorney, and making sure that you're doing the best that you can do and staying as compliant as possible as we continue to navigate this crazy world that we're in today. So with that being said, kind of the overview of the program, I already gave you a little bit about Cesco, but we are the oldest consulting firm in the country. We've been in business since 1945. We've got clients in all industries throughout the entire country, including state and national trade associations and their valued members or business clients. So it's a fun gig. I'll be 100% honest, because it keeps us on our toes, and we have the ability to foster relationships and support our business owners in making sure that they are on the straight and narrow there. So a couple of things with Virginia law updates. As a reminder, minimum wage did increase May 1st. You'd be surprised, but a lot of people didn't know that. And so make sure that you update your minimum wage posters. And there are a few other posters with regard to COVID pieces, and Virginia has delayed a little bit on releasing those things. You can get them free on the Virginia DALI website, the Department of Labor and Industry. So you might get inundated with those poster companies that are sending you things through the mail saying, oh, spend $200 on this. You can get all of your state and federal posters free online. You can also order them through Cesco for a very affordable fee if you like the all-in-ones, but that's up to you. No pressure from us, but minimum wage $9.50 per hour. Okay, as a reminder, it is going to increase in phases. It'll go to $11 and on January 1 of 22, $12 and 23, and then it goes back to General Assembly. Okay, so the game plan is that General Assembly prior to the end of 23 is going to enact the next 2 tiers. And so anything that happens legal wise in Virginia in terms of changes to laws, minimum wage, safety standards, EEO, any of that stuff that impacts employment regulations, it all goes through General Assembly. They are in special session right now, and they start their normal regular session mid-January, and it alternates years. Some years are 6 weeks in General Assembly, whereas others are 8. So if it passes General Assembly, then in 2025, it'll go up to $13.50. And by January 1 of 26, it'll be up to $15 per hour. Okay. So minimum wage is minimum wage. Minimum wage is not considered regular rate of pay, which will make sense here in just a minute. But it's important for you all to be thinking about, 1, making the necessary adjustments, but 2, be mindful of wage compression and the perception and the culture within your organization. So let's just hypothetically say I was an entry-level worker and I was making $10 an hour when minimum wage was $7.25. Okay. Now that minimum wage is $9.50, I'm only making 50 cents more than minimum wage, whereas I was making, $2.75 more than minimum wage. So that wage compression does occur. So make sure that you are challenging your current comp structure and making sure that we're looking at, is there compression, and making the necessary adjustments. Obviously, everything is always based on budgets and affordability and right price theory. So if you have questions regarding compensation, let me know. Lord have mercy. Sorry, the dog just stole a remote. That's real life here, people. So the other piece is, if the General Assembly does not act by 24, the 12-hour minimum wage will remain in effect, okay? And then they will adjust it based on consumer price index. All right. So Virginia Minimum Wage Overtime Act. We've been getting a ton of questions about this. Certain industries were impacted more than others in the Commonwealth. So If you happen to be in an automotive industry or a food and beverage distribution industry, or an industry that was using what we call fluctuating workweek method, you can no longer use those things. So basically what happened was the sponsorship of the bill wanted to create a overtime act where overtime was calculated based on 1.5 times regular rate based on a 40-hour work week. So this is where Virginia did something that is, quite frankly, I don't want to say vastly different, but decently different from what federal law allows. So for federal law, you can use or could use prior to July 1, you could use what we call a straight time method of calculating overtime or fluctuating work week, meaning you could pay me a guaranteed salary of, I'm just going to use easy numbers, $2,000 a week. Okay, but knowing that my job duties do not meet any of the federal exemptions from overtime. So I'm on a salary, right? But I'm entitled to overtime. So that salary would have covered all of my hours. And let's just assume for this week I worked 50 hours. So that $2,000 a week would have covered the 50 hours, which is the one of the 1.5 times of minimum wage. So under federal law, you would only have to pay me the remaining 0.5, the half time, for any hours that exceed 40. So 10 hours at whatever my halftime rate would be. Okay, Virginia wiped out that ability. And I know that sounds very complicated, but if you were using that straight time method of calculation, you understand how it is calculated. So Virginia no longer allows for that. So if you have individuals that are on a salary, but do not meet any of the white collar exemptions from overtime, executive, administrative, professional, outside sales, computer. Okay, there's 5. Exec, admin, yeah. Then they are entitled to overtime based on 40 hours and not the actual hours worked. So it changes your calculation. Okay, so again, it is really, really important that you look at who is currently paid on a salary basis and work with your employment attorney or your consulting team to make sure that you have properly classified salaried exempt status. Because if you have a salaried non-exempt individual, that straight time calculation isn't going to fly anymore. Okay, so it's based on, overtime is going to be based on 40 hours with their regular rate of pay and not the straight time. If you are found to be in willful violation, it is automatic 3 years back pay with liquidated damages. Liquidated damages is double. So let's just say I got slapped with a civil lawsuit, or Virginia Department of Labor came in and audited my wage and hour practices. And they said, gosh, Jamie, you've got 5 people on salary that are truly salaried non-exempt, and you haven't been paying them overtime. Okay. One, salary misclassification is both a federal issue as well as a state issue. Okay. But the state is going to look back at the last 3 years, and let's just assume I owe Mary Smith a total of $5,000 in back wages. Okay. Because liquidated damages is both written into the federal law as well as now the state law, that $5,000 automatically becomes $10,000. That $10,000 is paid to the employee. The extra $5,000 that you're paying with liquidated damages doesn't go to the Department of Labor or the Wage and Hour Division. It goes to the employee. And also keep in mind, there is no payment plan. When you get audited, whether it's state or federal, and they run calculations and they come back with numbers, you literally have 30 days to pay in full to all of the employees that were listed in that audit that were found to be due back wages. Okay, so you can also get 8% prejudgment interest penalty, and you will be required to pay the employee's attorney's fees. Okay, so it is kind of a big deal. We always recommend that you have a wage and hour audit from both a federal perspective, but now also a state perspective, to make sure that you are on the straight and narrow with wage and hour. A lot of misconception out there is that OSHA is your biggest, liability in terms of employment law. It is not. Wage and hour accounting is your number one liability. It is the most expensive because of liquidated damages, because of the willful penalties and the 2 or 3 years back wages and interest. I actually was just working with a very, very large group. Granted, they were in New England and they were on a federal basis, but it was a 9-month-long investigation of 22 locations to the tune of, over $1 million. And again, there's no payment plan there. And it's little things that can ding you on both the salaried exempt piece, but also hourly individuals that may be earning a bonus or a commission, and that are earning overtime with that bonus or commission, or working overtime. That bonus or commission has to be included in the regular rate calculation. So if I'm making $10 an hour and I'm getting overtime at 1.5 times my $10 an hour, but then I get a $200 bonus for the month because of a safety bonus or a production bonus, or anything that's tied to some sort of guarantee. If I hit this goal, or if I do X, Y, and Z, I'm going to get this money. That bonus has to be included into the overtime calculation. And a lot of employers don't know that, and that's where they get in some of these large calculations of back wages, because of regulations that are kind of, I don't want to call them hidden, because they're not hidden, they've always been there, but it's just not overly known. So with the Overtime Act, please look at who is on salary. Please make sure that their duties meet the white collar federal exemptions. If they do, I'm sure we do have a lot of questions, but if they don't, then we need to kind of look at options for making appropriate adjustments to get you compliance. All right, David, what you got for me?
Okay, so there are two. It says, so non-exempt full-time employees, it's time and a half beyond 40 hours in 1 week?
Yes, each work week stands alone for purposes of overtime. It's a great question, because a lot of employers think, oh, I pay biweekly or semi-monthly, and I can just average the work weeks together and only pay overtime over the 80 hours. And that's not correct. Each work week stands alone for purposes of overtime. That's federal law as well as state. So you have to look at each work week. Also, in your handbook, you should have in writing when your work week starts and when it ends. It is a 24-hour, 7-day period. It could be 12:01 on Sunday till 12 o'clock on Saturday night, whatever it is, but it is each work week stands alone for that 40 hours. Great question.
Okay, thank you. There's another one. This one may be, well, I'll pitch it out there, see what you say. What about salaried exempt employees over 40 hours?
Yeah, great question. If they are truly salaried exempt, then over 40 doesn't matter. Here's the thing, just paying somebody on a salary or just having the title of a manager or director is not enough. Okay, there are duties tests as well as salary threshold tests for the white collar exemptions, and each exemption has different duties tests. So for example, the executive exemption requires that I make a guaranteed salary of $684 per week, guaranteed regardless of how many hours I work. So if I work 1 hour, I'm guaranteed that $684. You can't dock me for that if I don't work the rest of the week. I also have to manage a department or division. And within that department or division, I have to have at least 2 full-time employees directly report to me. And I have to be managing more than 51% of my time, to include screening, hiring, firing, or making recommendations thereof, directing their work, performance management, coaching, counseling, discipline. If I don't meet one of those tests, they're non-exempt. It is an all or nothing mentality. So salaried, true exempt individuals, they can work 80 hours in a week. It doesn't matter. But if I have somebody that is on salary but is non-exempt because their duties don't meet the tests, now we have to go back and owe them overtime. So.
Gotcha. And there's just one more here. It says, is agriculture still exempt from Virginia overtime rules, at least for right now?
Yep, there are some exemptions in there. There are specific positions within agriculture that may be exempt. So what I would encourage is to circle back with me after this, and we can kind of dig into more specifics about what type of ag you are in and what positions you're looking at. Yep.
That's all. That's perfect. That's all we got for now.
Awesome, great. So here's an example of how overtime, you used to be able to calculate overtime using the straight time calculation with that salary divided by total hours worked to get the regular rate, versus now at the bottom with the correct calculation will be in Virginia for a salaried non-exempt individual. So at the top, remember I mentioned straight time or fluctuating work week. So that $700 a week salary would be divided by my 50 hours that I worked. That covers the one of the 1.5 times for overtime. And then I would get my regular rate of pay. So once I had my regular rate, you take half of that. So any overtime under the federal piece would have been paid at $7 an hour, the 0.5. But Virginia law does not allow for that anymore. So now the correct calculation is going to be based on 40 hours. So instead of owing $70 in overtime, now I'm going to owe that employee $262.50 in overtime for the week. Okay, it's a massive jump, right? It's a big deal. So make sure again that you have things correctly classified. Okay, let's talk about legalization of marijuana. There are still a lot of things kind of up in the air about this because it hasn't been tested yet under law and it has not been litigated yet. But effective July 1, employers are not allowed to discharge, discipline, or take adverse action against applicants or employees for lawful use of medical marijuana. The key term there is medical, okay? I have to have a medical prescription card to use marijuana in the state of Virginia. Just because I can have 4 plants at my permanent residence and use it for recreational use does not mean that that is going to fly as legal use for purposes of employment, okay? Got a lot of questions about that, a lot of pushback from employers that are confused on that piece. Medical use only. Now, does that mean that it's not hard to get a medical card? I'm not going down that rabbit hole today, but so you can't take adverse action. That does not mean that your hands are tied and that you have to allow people who are using for medicinal purposes to, remain employed or to be hired. So again, they have to be state registered. And we're looking at pre-employment drug screens and random drug screen tests, okay? One, they cannot use the marijuana while at work, okay? That hasn't changed. And 2, just because they test positive does not necessarily mean that you have to keep them, okay? We have to look at Americans with Disabilities Act. Okay, because a lot of folks that are using medicinal marijuana are going to be covered under the Americans with Disabilities Act as amended, okay, because of a disability. It could be cancer related, it could be anxiety, it could be seizures, all sorts of things, okay? So with that, if somebody tests positive, just like they would with any other pre-employment or random drug test, that medical review officer is going to contact the employee and say, hey, you've tested positive for marijuana. I need to see your prescription for it. okay? If they cannot produce a prescription or a medical card for it, game on, okay? You know, move forward and follow your drug-free workplace policy. However, if they do produce that medical card, then you as an employer are required under federal law as well as state to explore a reasonable accommodation. You have to look at what position and what duties are they performing? Are they safety sensitive positions? You know, can we reasonably accommodate this so long as they're not under the influence at work and it doesn't impact their ability to perform the essential functions of the job, okay? So there are options for employers. I know people are a little nervous about this, especially if you are in the trucking industry or production and you've got people driving forklifts and those sorts of things, or healthcare. It doesn't 100% tie your hands. It's just an additional step. It's no different than if somebody tested positive for painkillers and you having to go through the exact same process and looking at, do you have a prescription? Is the levels in your system within the use of that prescription? And we have to reasonably accommodate. Reasonably accommodate could be a variety of things. It could be you know, adjustments to schedule. It could be time off from work. It could be that you don't need to accommodate at all. So the other piece that I will also say is that, yes, you can possess legally up to 1 ounce of marijuana if you're 21 and over after July 1. But again, that does not mean that recreational use is protected underneath this law for purposes of employment drug testing. It's only medical registered use, okay? You can still have in your policy that they can't possess or use marijuana while at work or be under the influence at work, okay? Questions about that?
We have a lot of questions, but they're not necessarily about that topic. They're still coming in on the white collar exec duties and those. Do you want to address those now or wait till the end?
Yeah, we can go back, not a problem.
Okay, so got one. Where exactly do we find that list of specific definitions for white collar exec duties that make someone exempt?
Yep, great question. So here's what I'm going to do. I have a beautiful summary staff recommendation of all of the white collar exemptions and the tests that when I send David the PowerPoint, I will also attach in my email so he can send it out to you. But you can also find that on the Federal Department of Labor's website under the Wage and Hour Division.
Perfect, thank you. If I make $684 per week, is one exempt if they do not spend 51% of time supervising?
Nope. Again, it's all or nothing. Okay. It's the salary threshold plus all of the duties test. Okay. So again, this is where federal law, as well as now state, they really dig into job descriptions and they will interview your employees. So also keep in mind that if you get audited by state or Fed, or there's a lawsuit, they will interview your employees and you are not able to be present in the room. So if I ask David, hey, David, tell me where you spend the majority of your time every day in this position. And he's like, oh, I'm working alongside these guys and ladies and I'm doing administrative type work and I'm doing data entry and red flag, red flag, red flag. Okay. So this is why it's really, really important to have good written job descriptions that hit on the importance of high-level decision-making, screening and hiring responsibilities, management, percentage of time, because that helps refute anything that the employee may say. They may be honest in that interview or they could be completely dishonest. But if you don't have anything in writing that the employee has signed in terms of job duties and responsibilities, we have no way to refute that. So job descriptions are super important.
Gotcha. For business owners that self-pay, how is all this taken into account for business owners that self-pay?
Yeah, business owners typically are going to be considered executive exempt, assuming that you've got 2 or more full-time employees, that you are making high-level decisions, and you could be administrative exempt because you're running the day-to-day business operations. So I'm not super concerned about the owners themselves, so long as they're actively involved in the day-to-day operations.
Gotcha. How do we count for hours for currently salaried employees who have never accounted for their hours?
Great question. So remember, under federal law, non-exempt employees must maintain a true and accurate time card. Okay, hourly or salaried non-exempt employees. So if you have somebody that's on a salary that is not going to meet any of the duties tests, they need to keep a timesheet or clock in or whatever it may be. Because you have to have a record of their time. That's federal law. That's always been the law. State now just mirrors that.
Perfect. And last one, we changed the schedules in July to try to reduce or remove the overtime. Yep. Now I have several employees getting paid for 40 hours, but actually working 30 to 35 hours. How do I correct this and not make them mad?
Yeah. Oh gosh, that's tough. And you're right. You know, if we've got occasional overtime here and there, the easiest thing to do is always manage down the hours, right? Because payroll is your #1 controllable cost. So it really becomes a performance management issue. If they're being paid for 40 hours and they're not working the 38, 39, 40 hours that you have agreed to pay them that salary, then it's a performance management issue. One, you need to coach and counsel. Then you need to move into documentation of, you're not working your hours. Now, here's the double-edged sword, David. Let's just assume we've realized they really can do the job successfully in 35 hours. You can make adjustments to the salary. It's very difficult to reduce salary, especially when somebody's used to making that. But you have to be able to justify it based on the workload. And that is a very sensitive conversation to have. Do not just go in and start cutting people's salaries and make sweeping changes. Reach out, chat with a consultant so that we can craft a game plan and make sure that the culture and their perception, any sort of disruption to that is negated as much as possible.
Okay. And actually one more just came in. It says, are inside sales who travel to shows and visiting clients considered exempt? We are a wholesale business.
Inside sales is non-exempt. Now, there may be an option based on how they are compensated. If they are, primarily commission-based with a smaller salary, to use a partial retail 7I exemption for overtime. So again, this is why we should always be doing audits of positions, because even if it doesn't meet the white collar, you may have the option to use partial retail 7I. But there are also separate duties tests associated with that. But on the surface of it, inside sales is non-exempt from the federal basis. So we have to look at other options. Also keep in mind that travel time is compensable if they are non-exempt. So when I said wage and hour was a big bear and there are very, very complicated regulations, I was not kidding. The CFR, the Code of Federal Regulation for the wage and hour, is one of the biggest. And there are very minute things that can make or break you in terms of compliance. So happy to, if you reach out to me direct, we can talk more about the inside sales and look at what you got going on there and make sure that you're all squared away. Gotcha.
And if you have time for one more, it says just verifying that salaried employees should record their time.
No, that's not correct. Salaried non-exempt should record their time. If they are salaried exempt from overtime under the white collar exemptions, they are not required by law to record their time. However, you as an employer can certainly ask them to as well. It's a non-issue, but only salaried non-exempt are required by law to record their time, as well as hourly non-exempt individuals.
Okay. Okay. Well, do you want to, they keep on coming in, so do you want to keep?
Great, that's fine. Let's do it.
All right, so let me move these over, and it says, do timesheets need to reflect hours worked each day, or can it be summary of total hours worked that week?
Ooh, that is a fabulous question. So remember, federal law requires true and accurate, meaning when I go in and I audit my clients and I see a timesheet that's Monday through Friday, just 8, 8, 8, 8, total of 40 hours each week, I know that's not accurate, because what the timesheet needs to show is when they started their day, when they left for lunch, or dinner or a break, assuming that it's 30 minutes or longer, when they came back, and when they ended their day. Okay, true and accurate. None of this 8 to 5 thing. None of this just, total hours worked for the day is 8. Wage and Hour does not like it. They will ding you on it because they know it's not true and they know it's not accurate. Now, does it have to be 803 in a perfect world? Yes. But generally, round to the nearest 5 or to the quarter. Okay, there are also other methods of rounding, the 7/8 method of rounding up and back to the quarter hour that is permissible under wage and hour regulations. So having a detailed, specific timesheet, time clock system, punch system, whatever method you're using is going to be required. None of this general stuff. It's not going to fly.
Okay.
It's a great question.
Here's another one. Our nonprofit, non-exempt, salaried employee chooses to work overtime. We authorize 40 hours, so pay 40. Okay?
Nope, not okay. Not okay. If you have somebody that is non-exempt that is working overtime, whether it was approved or not approved, they are still legally entitled to be compensated for the time in which they worked. So you owe them that money. Now, what it becomes is a performance management piece. If they are actively working over 40 hours and you have not approved that, then you need to document and hold them accountable for violation of your policy, as well as working unauthorized overtime. But just because you have only authorized 40 hours does not mean that you are off scot-free and don't have to pay it. That employee would have the ability to file a complaint both with state and federal and engage in civil litigation because you owe them overtime and you have not paid it.
Gotcha.
So that's also all of these questions are really, really great.
Okay, perfect. I've got one more, well, actually 2 more. Here's one. It says, for a seasonal employer, does a manager have to for a seasonal employer, does a manager have to supervise 2 full-time employees all year round? Is it okay to supervise 2 in season?
It has to be 2 full-time at the same time. It doesn't have to be year-round, but at any given point in time, it has to be at least 2 or more full-time employees reporting to that manager.
Okay. And then what are the laws in having to provide break time per day?
Ooh, great. Virginia does not have break time requirements unless you're dealing with child labor. And in most cases, if they're under the age of 16, most people aren't employing them. But you may. If you have individuals under the age of 18, reach out to me. I will give you the child labor laws in Virginia because that is different. But overall, there is no requirement to provide any sort of break in Virginia, neither in North Carolina, West Virginia, DC, or Maryland. So If you are going to provide a break and you do not want to pay for said break, the employee needs to be completely removed from work, meaning I'm not sitting at my desk eating lunch and the phone rings and I pick it up. Okay, I need to be completely free from my duty, and it has to be at least 30 minutes or longer in duration. If it is less than 30 minutes or I am not free from my duties, it is time owed back to that employee. Okay. That is also something Wage and Hour will look at on timesheets where there's short lunch periods. Or if the employee is like, I always eat lunch and work at my desk at the same time, again, red flag for that investigator.
Okay. Overtime after 35 hours, if 35 hours is considered overtime, question mark?
Nope. Okay. Nope. Overtime is solely based on any hours that exceed 40 in a work week.
Okay.
So let's just, I think I understand what they're asking. So I'm assuming their question is related to my normal schedule is 35 hours per week, but I work 37 this week. Do I have to pay them overtime because it was more than what my schedule is? And the answer to that is no. Overtime is only going to be calculated for any hours that exceed 40 in a work week.
All right. And one just came in. From my understanding, we as employers have no control over what our employees do on their own time. So if they use marijuana, hey, we got a marijuana question. So if they use
marijuana. All right, let's go.
After work on Friday or on the weekend, and we do a plant-wide drug screen on Monday morning, and it shows a positive result.
Yep.
And that's the end of the question. I think we can figure it out from there, though.
Yeah, I think what they're asking is, what do I do with that? You are correct. You don't have control over what they do on their personal time. But again, going back to Virginia law and going back to your drug-free workplace policy, if they cannot produce a state registered medical use card, you follow your policy. If they test positive because they were having fun at a party on Saturday night and you do a plant-wide test on Monday and they pop positive and they can't produce that registered medical card, and your policy says a positive test results in immediate termination, follow your policy.
Perfect. Okay. Well, that's all we have, at least for this second. So.
All right. Those were all fantastic. Gosh, and it's already 9:45. That's awesome. Okay. So here's some additional Virginia law updates. Mask mandate, May 28th. The governor did say that vaccinated individuals can go mask-free indoors. This is where things are very fluid right now. So things are changing. You are starting to see retail operations saying, even if you're vaccinated, we still want you to wear a mask, okay? So yes, even though that the governor's directive on May 28th was that we can go mask-free indoors with vaccinated individuals, we expect that's going to change very, very soon because of CDC guidelines, because of increase in Delta variants and other things that are going on. Also, you as employers, regardless of what state you are in, need to create a policy for dealing with masks, okay? Remember that the Virginia Permanent Safety Standards for COVID required, masks indoors, safe, social distancing, so on and so forth. At the end of July, because of all the changes to CDC guidelines and what to do with somebody that is vaccinated but was exposed to an unvaccinated positive COVID person, Virginia is in process right now of tweaking the permanent safety standards. Okay, so yes, they're still technically in effect, but they're also fluid right now. And this is the hard part of being an employer right now where things are just crazy and, in process. So going back to your mask policy, and we have some information and hopefully we have enough time to get to it, but you need to decide whether you're going to mandate the vaccine or not based on your industry, based on exposure, based on comfort level. Please also know that there are always going to be exceptions to that mandate for both religious and/or medical exemptions. Okay, that's covered under the Americans with Disabilities Act. Your policy, if you're going to mandate it, you need to figure out who's going to be in charge of verifying the copy of the vaccine cards, where those are stored, which it has to be in a separate medical file because it's medical information. You may choose to do a visual inspection only. So there are policies and procedures that need to be in place, as well as training for the managers on how to address masks and vaccines in your organization. So speaking of vaccines, a lot going on with the vaccine. You're hearing a lot in the news about boosters and the variant, and I don't want to get into all of that, but more often than not, most people are vaccinated and supportive of the vaccine. However, I will say there seems to be a great divide in that opinion regarding vaccine or no vaccine. And there seems to be very few people in the middle of, how they feel. So good luck with those conversations, because it is highly debated and that sort of thing. But, again, things are very fluid with OSHA. They're updating their safety standards and vaccine and pandemic guidelines, again, as we speak. They tweaked them earlier this spring, and they're in the process of tweaking them again. Right now, no federal government mandate of vaccine. The old 2014 pandemic guideline was the only thing that OSHA had. They just issued the new ETS, the emergency temporary standards, but that applies to healthcare facilities only. Okay, healthcare only. So if you're a healthcare organization and you need a copy of that, let me know, but I'm pretty positive you already have that in place or should have that in place. But let's talk about Department of Labor, EEOC, that's the Equal Employment Opportunity Commission. They have gone on record and taken the position, even before COVID. Same thing with SARS, the flu, the H1N1. Certain jobs are going to be necessary or to require the vaccine. Okay, just like if you work for a healthcare organization or you go to the doctor, most of those healthcare facilities are mandating that their employees get flu shots each year. And if you don't want to get the flu shot, then too bad, so sad, we consider this a voluntary resignation. School systems have done it. Other businesses have done it. But again, there has to be opt-out for medical and religious reasons, okay? So here's what the EEOC wants you to consider if you want to mandate the vaccine. You need to look at, is it job related? Okay. What is the exposure that my employees day in and day out are, looking at in terms of customer facing type exposure? And is it consistent with our business necessity? If an employee refuses or fails to get the vaccine, is it posing a direct threat to himself or the coworkers or other in the workplace? Again, this is where we get into that highly debatable hot topic of increasing numbers, the Delta variant. If I'm unvaccinated and I go into, Capital One with 500 of my other coworkers in that building, am I a direct threat to them because I'm unvaccinated? And oh, by the way, I was just on vacation at the beach all summer. Okay. So not all, the whole point is not everybody needs to mandate the vaccine. Even in some healthcare settings, they're still not mandating the vaccine. Will that change in the next couple of weeks because of increase in numbers? We'll see. If somebody refuses based on medical or religious reasons, you have to explore a reasonable accommodation under Americans with Disabilities Act. That is paper trail, people. That is, getting some sort of medical certification from the doctor as to why they can't get the vaccine, and then documenting the reasonable accommodation interactive process. What we do encourage is that, you provide notice of benefits, risks, and side effects of the vaccine. If you are mandating it and somebody has refused to, provide it, and or they don't have a medical or religious exemption, you may have them work remotely, or you may also have to explore, other courses of action, but you can't retaliate against them for simply refusing the vaccine, again, because there are exemptions under certain contexts. Okay. I have also had a lot of questions from employers over the last few months about, should we bring in a Med One or a Better Med or whatever and do like a vaccine clinic on property for our staff, for whoever wants to get it? You need to check with your insurance liability carrier and make sure that, one, that's going to be covered in terms of, heaven forbid, some crazy thing happens at that clinic in your parking lot, that your insurance coverage is going to address that. We don't recommend at Cesco that you do those type of clinics on site. If you want to partner or provide vaccines free to your employees, one, most of the time it's covered underneath their insurance. But let's just say I have somebody that's not on the insurance. You as the employer can say, hey, I've got a contract with Patient First over here on, the boulevard, and you can go in and get your vaccine, and if you're not on our insurance, we'll cover the cost for you. Okay, so you can do things like that to negate your liability, but also it's still optional. And you kind of keep your hands a little bit clean in there. So EEOC says vaccinations are not medical exams, but if you're going to require the vaccination, it has to be job related, consistent with your business necessity, and it can't be more intrusive than necessary. Okay, so Title VII of the Civil Rights Act under ADA does allow for those reasonable accommodations. That's a federal law. That's not new. It's always been there. So if they have a sincerely held religious belief, and that religious belief is necessary and it opposes vaccines, that is enough for that employee to say, nope, not going to do it. Okay. You have to accommodate that sincerely held religious belief, so long as it would not result in an undue hardship to the employer. It would not shut you down. It would not cost you thousands upon thousands of dollars. It's really hard. I'll be 100% honest. It's really hard to prove an undue hardship, okay, for something like this. So, let me know if that pops up and let's talk about it, because each case is going to be individual. The reasonable accommodations under ADA, a disability. So if I have any sort of medical condition that qualifies as a disability and that vaccine may impact that disability, the employee's medical provider may provide you documentation that says it's not recommended for so-and-so to get the vaccine because of this. Again, you walk through that interactive process. And if you can't do a reasonable accommodation, again, it still has to be an undue hardship, which you're going to have to prove. Okay. If we have any union organizations on the call, please check with your collective bargaining agreement to make sure that any change on policy or mandate in vaccines or that sort of thing is not going to violate your CBA. And you may also have an obligation to re-bargain the terms and conditions of employment for that. Okay. So with the direct threat analysis, the EEOC kind of breaks it out and how you can do the individualized assessment. 4 factors that you're going to look at. What is the duration of the risk? What is the severity and the nature of the potential harm? What's the likelihood that the potential harm will occur? And the imminence of potential harm. So similar to how Virginia employers went and did their hazard risk assessment when those temporary safety standards came back out in 2020, you need to similarly do a direct threat analysis if you plan to mandate the vaccine. EEOC does state that if you plan to, do the threat analysis and an unvaccinated worker does pose a direct threat, you can't exclude them for the workplace unless there is no way to provide a reasonable accommodation. Okay, so that's when you look at, can this person work from home? Can I give them their own office or adjust their schedule so that they are not, interacting or in close contact with workers? Exposure now, CDC is saying less than 6 feet for 15 minutes or longer in duration. And again, that guidance changes weekly at this point. So always stay up to date with CDC and OSHA guidelines because those are changing. And we will also at Cesco keep our clients and our bankers folks updated through weekly blasts, newsletters, all that sort of thing. We also have a Cesco website COVID tab banner at the top of our website that you can check to make sure there's a ton of information there on the vaccine. It should be uploaded shortly with sample policies on voluntary, mandated, forms for reasonable accommodations, that sort of thing. Okay. Other alternatives to the vaccine that you may want to consider is, changing the workspaces, remote work, enhanced safety or PPE, face masks, shields, so on and so forth. But termination really should be your absolute last option, and only if that person represents a direct threat. Okay.
Got a few questions if now's an okay time.
Yeah, it's great.
All right, so we'll go ahead and we'll move into a question and answer session. And it says here, do you recommend that COVID or mask policies be included in the employee handbook, or is the separate policy adequate? It is continuously changing. So what are your thoughts?
Yeah, great question. I like to keep them separate right now because it continuously changes. But two, you don't want to have to reissue that handbook every single time something changes. So keep it separate, and then you can always add in an infectious disease policy or a general statement that refers to a separate memo or what have you. But keep them separate. It makes your life easier. And then every time you change it or update it, reissue it and make sure the employees sign or initial. It could be electronically, it could be a physical copy.
Perfect. Thank you. It says, here's another one. We are a medical practice that mandates vaccination and mask for our employees. Is this acceptable if we document the mandate in our policies?
Yes. And medical facilities also do have OSHA ETS standards that they have to comply with regard to masking, as well as Virginia Department of Health has other standards in place. So yes, mask and mandate is 100% fine. It should always be in policy as well. Okay.
Is it possible, and I think you might have answered this, is it possible to certify a religious exemption or necessary, really?
No, you can't certify it. That's the hard part. And I would say that with any other religious accommodation related to scheduling or, anything else employment wise, there's no way, EEOC says there's no way for you to, you can't require them to go to their pastor or their rabbi or whatever and say, oh, Jamie belongs to this synagogue or to this church. It's just not appropriate.
Gotcha. Hey, I do want to be sensitive to everyone's time, but Jamie, if you're okay, are you okay with time to continue on with these questions?
I've got just a few short minutes.
Okay, so we'll do one or two more, and then we'll make it a wrap. Can an employer require employees to get vaccinated in order to qualify for a wellness credit toward the employee's healthcare insurance premiums? If so, are there any limitations or requirements we need to satisfy in order to do so?
Oh, so now we're getting into ACA wellness plans with regard to a credit or a penalty. And so with that, I would say there always has to be a reasonable accommodation for people that cannot get the vaccine in order to receive that credit. It's no different than when an employer sets, required activities or certain thresholds to get a discount on their insurance, like quitting smoking, or BMI has to be under X percentage, and your cholesterol level has to be between this and this. There always has to be reasonable alternatives. So I actually want to dig into that a little bit more, because the vaccine mandate piece in the EEOC has not necessarily addressed ACA with a vaccine yet from that perspective. So that is an amazing question. But I would be inclined to say I would try not to do that. Now, you can give bonuses related to vaccinated workers. But remember, if I'm salaried non-exempt or hourly non-exempt, that bonus for my vaccine must be included in the overtime calculation.
Okay. Well, let's say this. What I'd like to do is there are several questions left, and I'd just like to re-emphasize that, hey, these are all great questions. So please, by all means, reach out to your sales executive, to your insurance sales executive. They can put you in touch with Jamie or Cesco just for this purpose, for answering questions just like this, by phone, by email. And with that, I'll go ahead and say again, Jamie, thank you so much. This was extraordinarily helpful. Thank you for taking the time. For all our clients that are on the line, thank you guys for trusting us as your insurance agent. And just wanted to say thanks to everybody. And if you have any questions, if you're not a client of ours but you want to be, by all means, please reach out to whoever invited you. And we'll go with that. Thank you so much.